Welcome all to this first presentation all about trusts and trust law. If you have watched my previous videos, then you will know that I have hinted at trusts a lot. And finally, here we are. You have now made it to the start of all things trust related. So this area of the law has much to be said about it. We will be going over things slowly over 7 presentations, all building upon each other. This presentation is the foundational knowledge in trust law presentation. So we will be diving into what a trust relationship looks like practically, how you can begin to recognize trusts, and the rights that beneficiaries of a trust have. And we'll also be touching upon the different categories and subcategories of trust that also exist out there. So without further ado, let's get started. So first, we need to set the scene by looking at definitions. When we look at the etymological root of the word trust, we can see that it comes from the Old Norse words traustu, traust, and trausta, which, let's just imagine I said that completely correctly, okay? So all of these mean strong. So the literal meaning of the word trust is that which is strong, protected, and stable. So this is really key and makes so much sense as we begin to learn more and more about trusts. Hopefully you will see just how strong they are as a legal arrangement. So when we look at the law definitions in particular, there are a few that help to clarify what trust means in a legal context really well. So the first definition that I have here is an equitable or beneficial right or title to land or other property held for the beneficiary by another person, in whom resides the legal title or ownership, recognized and enforced by chancery courts. So you can see that I highlighted some key words, including equitable, title, property, beneficiary, ownership, and also chancery courts. So these key words will be important to know as you begin to get more of a full idea of what trusts are. The next one is 1. The right enforceable solely in equity to the beneficial enjoyment of property, to which another person holds the legal title. A property interest held by one person, brackets the trustee, at the request of another, brackets the settlor, for the benefit of a third party, brackets the beneficiary. So notice this time I've highlighted some words including solely in equity, beneficial enjoyment, interest, person, and also third party. Again, keep all of these in mind as we move throughout this presentation. And lastly, there is this one, which states that a trust is 2. A fiduciary relationship regarding property and charging the person with title to the property with equitable duties to deal with it for another's benefit. The confidence placed in a trustee, together with the trustee's obligations toward the property and the beneficiary. This time I highlighted fiduciary relationship, equitable duties, and trustee obligations, as these words really stand out as highly important, which we will discuss in more detail in just a moment. So the words I have highlighted, unless you already know what they mean exactly, it's almost as if they require their own definitions for you to first know, so that you can actually grasp what the law definitions of trust were even getting at in the first place. So the words that came up included a few that I just wanted to run through their own definitions for you so that you aren't really left more confused than anything else. Firstly, what do we mean by right? This refers to an entitlement that you have to do or not to do something, which will then be protected by law. Next, title. So title means the right to own, use, or control property, and a title will usually be evidenced in some sort of writing, which you can then use to prove ownership rights of an asset if you ever need to. Next is interest, which is simple. It just refers to a right or claim to property of some kind. Then we have beneficial or equitable title. So these two terms are interchangeable. They essentially mean the same thing, and they refer to the right to enjoy property and to use it, even though the legal title may be held by someone else. Then, legal title. This refers to the formal ownership of property at law, which will give the holder of that right the right to control that property, to transfer or sell it if they want to. But this doesn't necessarily mean that they get to enjoy the property. As you have seen from the previous definition of beneficial title, it's the one with the beneficial title that actually gets to enjoy the property and anything that comes from it. Next, what do we actually mean by property? Well, this is literally anything that can be owned. So, this can be physical things like land, which is the most obvious one, or it can be intangible things like intellectual creations. Essentially, anything that has been created by someone will automatically be their property, which they can do whatever they like with it, obviously within reason. Next is beneficiary. So, this is the name given to the one who benefits from the trust assets, so they will have the beneficial or the equitable title. Next is trustee, which is the one who's appointed to manage the trust assets for the benefit of the beneficiary, which obviously has to align with the terms set out in the trust agreement, which is the legal agreement that is usually written and signed so that the trust can be recognized by the law. Then you have ownership. This is the right to possess, use, and control property and to dispose of it as desired. And lastly, we have fiduciary. So a fiduciary refers to someone who has a legal duty to act in the best interests of someone else, above and beyond their own interests. So I hope that covering these definitions as well, you can understand the law definitions of trust even better now, and that things are really starting to take shape quite nicely in your mind. So we've talked definitions of so many words. Now let's put all of these concepts together and define trust in a very simple way. So a trust is a legal arrangement where someone gives property to another to hold for the benefit of someone else. So what this really is, it's the conceptual splitting of ownership title. Because if you remember, ownership refers to the right to possess, use, and control and dispose of the property. Well, this is what we can refer to as absolute ownership, because you can do everything possible to that property. But the moment a trust is established, this absolute ownership is split into legal title and beneficial title. It is important to remember that this is obviously a conceptual thing. In reality, the property exists just as it did before. All that has happened is that in the mind of man, the rights to that property has changed. And of course, being a legal arrangement, this means that it is an arrangement that can only occur through the use of law. Trusts are not independent of the law. They are creatures of the law, as is, for example, the idea of a corporation. So hopefully you have recognized from the definitions and the constant use of the word equity and so on, and also from previous presentations too, that trusts are a creature of the law, but specifically the branch of the law called equity. Trusts can only be enforced in equity as there is no other at law branch of the law that could accommodate such a concept. There are also trusts that can occur through statutory provisions or by operation of law in common law, but just because these trusts came into existence through statute or common law does not mean that equity is not present. It means that those trusts will be enforced in equity. So equity will compel the parties to their duties and their obligations, which will be associated with this legal arrangement, regardless of how that legal arrangement the trust came into existence. So, equity's role in this whole ordeal. So, because trusts are ultimately creatures of equity, this means that it will be courts with equity jurisdiction that will supervise the management and also the enforcement of these trusts. Which, if you recall from the presentation on equity law, that the Senior Courts Act of 1981 shows us that equity is available at all levels of courts. So any court should be able to deal with trust matters, obviously, depending on the complexity of them. So it also means that equity will impose fiduciary responsibilities onto the trustee or trustees if they're more than one. And then it also means that equity will provide a remedy in the event that the trustees breached their duties, for example. So it will be the equitable remedies that will be used to correct any disputes. From all of this, hopefully, you'll be getting the idea that the at-law side of the law is the side that will recognize the ownership rights very easily. So that's where title rights will be recognized and then also evidenced. But in equity, well, equity will be the one to recognize more the intentions of the party and will enforce accountability and adherence to the legal arrangement, basically to ensure that everyone is getting exactly what they're entitled to from this arrangement. So, I would like to cover the concept of splitting of title in a way that's quite visually appealing so that you can see it happen as such. To do so, I would like you to just picture a chocolate bar, right? And I want you to imagine that this chocolate bar is the physical representation of ownership of property, specifically the absolute ownership to that property. So, this full chocolate bar represents the complete and unrestricted right to the use, control, and disposal of property without any sort of limitations or conditions, right? Now, imagine that this absolute ownership chocolate bar belongs to Happy Harry. So, Happy Harry is holding his ownership chocolate bar in his hands. He's so happy. He's the holder of the absolute ownership. But he holds absolute ownership of what? Well, this ownership chocolate bar represents the ownership rights that Harry has to a beautiful red bike. So the bike is the property, and the chocolate bar is the physical representation of his ownership of the bike. So this is his right to possess and use, as well as control and transfer the bike as he wishes. Then one day, Happy Harry was just so happy with his red bike that he decided he wanted other people to share in the happiness of his bike as well, because it's just so beautiful, right? So he had the idea to grab his ownership chocolate bar, grab a hammer, and he just went for it. He took out any sort of frustrations he may have had, and he just went crazy and broke it apart. The result is that he now broke the once whole ownership chocolate bar into two, exactly in half, where now the ownership of the beautiful red bike has just been split into two. So he has now been left with one half representing the legal title and the other half representing the beneficial title. Happy Harry then decided that he wanted to keep the legal half of the chocolate bar, so the right to control the bike, and he decided to give the beneficial title half of the chocolate bar to his friend Grateful Greg. So now it is Grateful Greg that has the right to enjoy the bike. So Happy Harry holds the legal title, and Grateful Greg now holds the beneficial title. In reality, what this looks like in terms of the actual property now, so the bike. Well, it means that Happy Harry has said that he will sort out any of the costs and the maintenance of the bike, whereas Grateful Greg is going to be the one riding the bike out and about, obviously taking his helmet with him so that he's safe on the roads. So, what has actually happened when we look through the lens of the law is that a trust has just been created. What this looks like through the law lens in this scenario is that Happy Harry acted as settler. So he created the trust because he owned the bike and the absolute ownership to the bike in the first place. Then he decided to make himself trustee by accepting the maintenance and the cost responsibility. And then he made Grateful Greg the beneficiary who will be able to actually use the property of the trust, which is the bike itself. The bike itself is referred to as the trust res or asset, as this was the property that was subject to the legal arrangement that Happy Harry decided to make. So hopefully you'll be able to recognize that a settler has to have full rights of enjoyment and control of a property type. So they get to use it as well as having to maintain it. And this is what we call having absolute ownership. So ownership of something outrightly or completely. No one else can logically therefore have any rights to the same property. This settler can therefore decide to make a trust and will set out the rules of how this property is going to be handled. Then you have the beneficiary, who will have the rights to enjoy the property, but doesn't have to pay any costs at all. The property, in this case the bike, is not fully their property though. It is still considered property of the trust, which they have beneficial rights to only. Then you have the trustee, who has a right to control the property, obviously in line with the rules of the trust as set out by the settler, which will be set out hopefully in a verbal agreement or a deed that is written down. The trustee then becomes liable to maintain the trust asset and obviously any costs associated with it. They will also be the one able to sue on behalf of the trust if there are any legal issues, because the trust itself has no legal personality. It is the trustee who must rely on their legal personality to be able to handle any legal disputes. So very simply, the settler creates the trust and puts property in it. The beneficiary receives the benefits of this trust relationship, and the trustee manages the trust and controls the legal title to property and obviously the legal rights that come with it. So this example we've just explored shows you a trust where the settler becomes the trustee for the benefit of his friend. However, this is not the only way that a trust can be structured. This arrangement is flexible and it can be shaped into whatever the settler really wants, obviously within reason and the bounds of the law. The settler doesn't have to become the trustee. They could be the beneficiary instead, and someone else is the trustee. It could even be that the settler completely gives up all rights to the property, so giving the legal title to someone else and then the beneficial title to another, so that they end up with no rights at all. It could also be that the settler is in every position of the trust at one time, just they cannot be the only one, so there will have to be either more trustees with them or more beneficiaries with them. So hopefully you can see that trusts are very flexible and how they look will completely depend on what you're trying to do with the trust and also how many people are party to it as well. Now let's touch briefly on the two most basic types of trusts. So these are revocable or irrevocable. So revocable essentially means that the settler can actually change the terms of the trust or remove assets or cancel it at any time whilst they're still alive. So they end up retaining control in that sense in their position as settler. Then you have irrevocable, which essentially refers to trusts that once they're set up, the settler no longer has any involvement in their position as settler. The complete control is now transferred to the trustee completely. So, what rights do beneficiaries actually have? Well, beneficiaries have two rights to the property that are held in trust for them. So these are proprietary rights to the trust property itself, so the right to use it. Then the other is personal rights against the trustees, so to ensure that the trustees manage the trust property properly, right, in line with the agreement or the deed. So it is important to note here that these rights are very much recognized by law. These aren't some fluffy ideas of rights that beneficiaries have. These are actual rights that have been enforced in courts of equity since the 15th century. So they're a big deal and they have stood the test of time. These rights that beneficiaries have aren't just enforced against trustees' right, they are also enforced against anyone who may claim to have a right to the property that is subject to the trust. So, beneficiary rights have been upheld and enforced even against all other people who may claim some sort of right to the same property. But of course, this means that any third party to the trust has to be notified of the trust being in existence beforehand, so this notification should be done as soon as reasonably possible. So, what are trusts practically used for? Well, they're used for a variety of purposes, and this includes for estate planning and inheritance, to protect assets, for the creation of pensions and also investments, to allow joint ownership of the same property, for commercial and business uses, and also for private family arrangements. So you can see that trusts are actually found in a variety of areas. So knowing about them and being able to recognize them and also use them is really key for you to fully grasp. Now, do trusts need to be registered? So, according to the book Equity and Trusts by Alistair Hudson, the 10th edition specifically, it reads as follows: Trusts do not require registration in England and Wales, nor are they required to publish accounts. Therefore, there is no specific oversight of trusts, although some specific types of trusts, such as pension funds, are regulated by statutory regulators. So we can see that there is no specific need to do so. However, some trusts that are regulated by statutory provisions will be registered in some way. Now, who can actually set up a trust? Is it a lawyer? Is it a judge? Well, actually, anyone can set up a trust. All that is required is for the settlor to be of legal age, so 18 and over, and also sound of mind. If these two requirements are met, then they can settle a trust at any point. The key here is that the settlor must have the ability to own property in their own right first, so the absolute ownership. Then they can settle any number of trusts if they want to. A little side note here, which will be discussed in further presentations, is that a beneficiary can actually place their beneficial title to an existing trust into trust as well. But don't worry about this for now. We will be going over this in future presentations once you have other foundational knowledge first, so you'll be able to understand how this is possible. So, yes, anyone with a legal personality, so having to be a legal person, can set up a trust or be party to one. And this also includes companies. Also, any legal person can occupy any position of a trust. And it is also possible, for example, for a beneficiary of a trust to actually be an existing trust, which would mean that the beneficiary will actually be a trustee of another existing trust. So, again, you can see how flexible these arrangements are and also how complicated they can get very quickly. Right, now let's touch on the categories of trusts. So these are express and implied. What do I mean by this exactly? Well, express trusts are trusts that are created intentionally by a settlor, where the terms of the trust are set out in writing, or they're given orally, or they're evidenced by the conduct of the parties themselves. Then, on the other hand, you have trusts implied by law, which refers to trusts that arise automatically, so without a settlor involved, because it is the courts that create them by recognizing that equity requires a trust to be imposed. Then, of course, from these categories, you will have subcategories or subtypes, which there are many. And being able to identify which type you're working with will depend on a few things. For example, the way the trust operates, how the trustees manage the assets, who is benefiting, when they are benefiting, and the powers that the trustees have. So, very quickly, some examples of express trusts include bare, discretionary, charitable, interest in possession, will, and disabled persons trusts. Then, within implied, you have resulting and constructive. We will get into what all of these actually mean in upcoming presentations, so don't worry about them for now, one step at a time, right? Okay, so we have gone through loads of groundwork in this presentation. So we have covered the etymological and legal definitions of the word trust, the common words closely associated to trust that you do need to know, for example, ownership, title, and property. We've demonstrated what a trust relationship would look like practically. We've shown you how to recognize that a trust relationship is at play. We've looked at the difference between revocable and irrevocable trusts. We've looked at the rights of beneficiaries, the practical use of trusts, the registration requirements of trusts in England and Wales. We've talked about who can actually set up a trust. We've gone through the different categories of trust and also the subcategories. So we have reached the end of this first presentation on trust law, and hopefully you have started to get a good foundational understanding on what trust law is all about, and hopefully this has helped illustrate what a trust looks like in real life and how useful that they can be for a variety of reasons. Of course, as this is just the beginning, I've tried not to overload you too much with information, but I look forward to getting into even more detail with you in the next upcoming presentations. So you will really grow to get a very good sense of trust law and begin to notice how beneficial they can be for you. So if you found benefit in this presentation, then please leave a like, share it with someone who may also find benefit just like you, as everyone here can be a beneficiary, and make sure to subscribe for more law educational videos. Thank you for watching and see you in the next presentation. Bye bye now!